Because no one sees your screen. On air. Okay. Good afternoon. This is Sarah Thomas. I'm the legal counsel at the Tennessee Coalition to End Domestic and Sexual Violence. And you have tuned in to a webinar on Title VI. So hopefully you're excited for this webinar. Everybody loves Title VI. So let's go ahead and get started. There we go. What is Title VI? Title VI is a federal law which prevents any entity receiving federal money from discriminating against anyone because of race, color, or national origin. Also note that when an agency like ours serves a number of non-English speaking persons, that it might be required to provide interpretation or translation. Language services relates to national origin. So we're going to talk more about that LEP requirement later. So what does the law say? Do I need to move this out of the way? No, okay. The law says that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So we're going to go through this and break it down a little bit so we can understand more what it means. So when they say no person in the United States, that means a citizen or a non-citizen. It also means documented or non-documented. And it could be a corporation or an individual as well. When it says United States, that also includes territories. And then financial assistance includes grant-funded agencies. The coalition is a grant-funded agency, and so we receive financial assistance from the government. When it says subjected to discrimination under any program or entity receiving federal financial assistance, this means that the law only applies to entities that receive funding. So an aggrieved party or someone that claims discrimination cannot sue an individual or an employee of a program for discrimination. So if there is the head of a housing organization, you can't sue that person in their individual capacity or in their capacity as an employee. You can only sue the organization. This is codified. It says that on the left under 42 U.S. Code 2000D, the Department of Justice is responsible for coordinating the implementation and the enforcement of the law pursuant to an executive order. So the Department of Justice implements regulations and guidelines and directives for this law, and you can find those all online as well. Okay, what programs are usually covered under this law? Usually elementary, secondary, and higher education, healthcare, social services, and public welfare, public transportation, parks and recreation, law enforcement, housing and community development. So social service could be the Department of Children's Services, public transportation could be busing, housing could be HUD programs, also victim service programs that receive federal funding, and that's probably most of you all who are tuning in. All right, what is not covered? So employment is not covered except where employment practices result in discrimination against program beneficiaries or where the primary objective of the federal assistance is to provide employment. So, for example, if a recipient of the federal funding builds a temporary shelter with funds designated to provide assistance to homeless, the employment practices of the recipient with regard to the construction of that facility would not be subject to Title VI. However, if the same recipient builds the same facility with funds received through a public works program, whose primary objective is to generate employment, then the employment practices would be subject to Title VI in that case. So in the former case, the program's benefit was to provide shelter, but in the latter, the program's benefit was the employment of the individuals to build the facility. So to sustain a Title VI claim of employment discrimination, the plaintiff has to show, number one, that the recipient of the funds receives federal financial assistance, and two, that the primary objective of the federal funding is to provide employment. What else is not covered under Title VI? That is discrimination based on age or sex. That's not included in Title VI. However, Title VII prohibits employment discrimination based on race, color, national origin, religion, or sex. Okay, what is federal financial assistance? As I talked about it a minute ago, it would be grants. Most of us nonprofits and victim service agencies, we receive financial assistance through grants. It could also be training, the use of equipment, construction money, donations of surplus training, or other federal assistance. If your agency receives even $1 of federal money, then Title VI applies. Let me give you an example of construction money assistance. That one's sort of a confusing one. So say a university received federal grants and loans and interest subsidies from the Department of Education to construct a law school. So it's clear after that that they received federal funding and they have to comply with Title VI. However, after the school is built, if the university still uses that school, it still has to comply with Title VI. So even if you no longer receive federal grants or funds, but you still use the equipment that you bought or the building that you constructed with the federal money, then you're still a recipient of federal funds and you're still bound by Title VI. The clearest way you can determine if you're a recipient of federal assistance is to determine if you voluntarily entered into a relationship with the federal government. So this is a contract. This is contract law. So if you choose to accept federal funds, then you assent to the regulatory power of Title VI and its regulations. Also, I know the coalition has a number of subrecipients to our contracts, and if you are an agency that is a subrecipient of federal funds, meaning you don't get your federal funds directly from the government, but you get it from another agency, or you get those funds from the state and the state gets it from the federal government, then you're still subject to Title VI in that case. And again, for agencies like ours, where we're a direct recipient of federal funds, but we have subrecipients, then we have an obligation as the coalition to ensure that our subrecipients comply with Title VI. All right, so what is the purpose of Title VI? Well, it's to make sure that everyone has access to federally funded activities. This could be WIC, court access, legal services, public transportation, things provided by the federal government. Our government just wants to ensure that if it provides benefits through funding to programs, that those programs will take into account, where, for example, where it locates its facilities, and will take into account and make sure that it's not doing things that are going to discriminate against one class of people over another class of people. Okay. What are some other purposes of Title VI? Well, it could be to encourage the participation of minorities as members of planning committees, boards of directors, or programs receiving federal funds. Prohibit discriminatory activity in a facility built in whole or part with federal funds. Another purpose is to require information and services to be in languages other than English when those services are provided to a significant number of beneficiaries who are limited in their English-speaking ability. So Title VI really wants organizations to faithfully represent the communities they serve. What discriminatory activities are prohibited? Well, if you're operating a federally assisted program, your agency cannot, on the basis of race, color, or national origin, either directly or through contractual means, deny a program services, aids, or benefits, provide a different or inferior service, aid, or benefit, or provide a benefit in a manner different than it's provided to others, or segregate or separately treat individuals in any matter related to the receipt of any service, aid, or benefit. So this brings us to disparate impact, and this can go really deep in the weeds, and I don't really want to get into the weeds, but I will give you a couple of fact patterns for you to consider. So if policies or programs disproportionately impact minority or low-income populations, this could give rise to a Title VI claim. So, for example, if your organization locates landfills consistently in a highly populated African-American community, but that same organization never locates any landfills in any other type of community. And whether Title VI has been violated is really a fact-specific inquiry. You'll need to consider the proportion of persons in a protected class of people who are adversely affected by a policy compared to persons not in a protected class who are adversely affected. And if a high proportion of protected class persons are affected, then Title VI might be violated. But you also have to determine in that case whether the benefits to that affected group could outweigh the harm and whether that harm is great. So, for example, say a hospital is moved to a new facility farther away from a large minority population who is using that hospital. Though the moving of that hospital affects that community more than other communities, so there is a disparate impact. It's more difficult now for that community to access those medical services since the hospital is farther away. That could be tempered by the fact that the hospital now has a better facility and maybe is able to provide better services. So again, the determination of whether there is a disparate impact to a section of our population is really a fact-specific analysis. Okay, so what is limited English proficient and why do we care about that? This is really part of Title VI, and part of what Title VI is trying to do is to ensure that people that are not proficient in English get the services and the programs that are provided to the rest of the population. So persons who do not speak English as their primary language and who have a limited ability to read, speak, write, or understand English can be LEP. The federal government and those receiving assistance from the federal government have to take reasonable steps to ensure that LEP persons have meaningful access to the programs, services, and information those programs and entities provide. And the authority for the LEP is an executive order that was signed in 2000 by President Clinton. So what are the LEP requirements? Well, the covered agency is required to take reasonable steps to ensure meaningful access to their programs by LEP persons. So reasonable steps could include using interpreters, posting signs in Spanish or whatever language is routinely used in that area, or using language line. So as I said, I work for the Tennessee Coalition, and we have 2 legal clinics, one of which serves immigrant victims of domestic violence. So we know that a majority of those clients are not English speaking. So we would be violating Title VI if we refuse to provide any interpretation or translation for the majority of our clients. So a reasonable step for us to take to ensure meaningful access to the population that comes to get help from us is to ensure that we have bilingual staff and to ensure that we have enough money to call language line to get their services if we have someone that comes and doesn't speak English. But what if we had one client per year that speaks a really rare language and we can't find anyone to translate that language or interpret that language from LanguageLine? Do we have an obligation to provide legal assistance in that person's native language? Probably not. That probably isn't required because that's not really reasonable to require us to be able to translate and interpret for every type of language that could be out there. So normally most of our clients are Spanish speaking, so we know that we need to have bilingual Spanish speakers here. For our other clients, we use LanguageLine, but I don't think that we are required by Title VI to go out and hire somebody who speaks every language that could possibly be out there. So a program doesn't have to do anything and everything to accommodate a small number of people. It just has to take reasonable steps. So what are some proactive steps to ensure compliance with Title VI? So the best practice, number one, would be to distribute Title VI information among your organization and your employees. So make sure your employees and the general public have information on your Title VI procedures and policies, including a complaint procedure. That's important. You could distribute this stuff on your website, in brochures, other forms of media. Best practice number two, have a complaint process. The complaint should really also contain definite timelines for filing a complaint and also for responding to a complaint. Generally, it's a good idea to have somebody in your organization who is assigned as the Title VI coordinator. That person should be in management. They should keep the complaints on file and they should be kept confidential. The Title VI coordinator should be a point person for ensuring everyone gets trained every year and that whatever complaints come in, if there are any, that they're investigated. All right, here's an example of a complaint process. Complaints must be written and signed and filed within 180 calendar days of the Discriminatory Act. They really should be written and signed. It's best for your agency to have a form that an aggrieved party can fill out asking for this information, so you don't have to interview the person to get this information. However, the aggrieved party by law doesn't have to be the one filling out the complaint and doesn't have to use any particular form. So as long as they submit and give all the information that's necessary, it doesn't have to be on a specific form, and someone else can also fill out the information for the aggrieved party. The complaint should include a name, address, phone number, and other identifying information. The name of the person or agency who discriminated against the person, how, why, and when they believed they were discriminated against. And really your complaint should have timeframes both for investigation and for also letting the aggrieved party know the results of the investigation. Okay, what's best practice number three is to conduct a Title VI self-evaluation. So make sure your employees have been trained, that there's a Title VI coordinator, and that you have properly evaluated any complaints. So here's sort of a list of things that you can look at to determine how you're doing in terms of your obligations under Title VI. Make sure an employee has been appointed to serve as a Title VI coordinator. Try to determine if minorities are represented on the advisory board. Generally, if at least 5% of the population in your geographic area are minority persons, it's really a good idea to have minorities represented on your board. Make sure a written procedure exists for hearing and reviewing Title VI complaints. Make sure that there are records maintained regarding any alleged cases of discrimination, and make sure that the staff are really informed about their individual rights under Title VI. Make sure you keep all the records of any alleged discrimination, even if it's determined that there is no discrimination. Keep those records just in case someone comes back and says, you know, I alleged discrimination and nothing happened with it, and I want to know why, and they want to take it further. You have those records. You also want to make sure that the staff are periodically apprised of their Title VI rights, and that when you are doing contracts between your agency and other organizations, if you have subrecipients, that those contracts are provided without regard to race, color, sexual orientation, or national origin. It's really a good idea to have a specific statement of compliance in all of your subrecipient contracts. It's a good idea to have Title VI posters prominently displayed in your organization, and also posters that identify the coordinator for Title VI. It's also a good idea to have a Title VI statement, again, something that you can put in contracts and that you can post in posters. This is our Title VI statement. It shall be against the policy of the Tennessee Coalition to End Domestic and Sexual Violence to discriminate against an individual based upon that person's race, color, or national origin. This policy applies to applicants for employment and current employees, as well as persons receiving services from the coalition. So we're trying to cover everybody in that statement. So what happens when a covered agency is not in compliance? So there could be a withholding of payments to the recipient until the recipient becomes in compliance. So if you have a subrecipient and you monitor that subrecipient, and you have determined based upon your monitoring, whether that's a desk audit or an in-person audit, or whether it's just by a phone call, if you have determined that they are possibly not in compliance with Title VI, you really need to investigate that. You really need to work with them to determine what they can do to be in compliance. And if they don't willingly comply after a period of time that you give them, you may need to consider terminating funding to that particular subrecipient. If you, as an organization, are not in compliance with Title VI, it's possible that the federal government could cut you off from funding as well. So there could be a cancellation, there could be just a suspension of the contract as well. And generally, you know, the government will work with you if you need help developing some Title VI policies, if you need help, you know, coming into compliance, having a complaint procedure, understanding what your obligations are. They will really help you with that before they terminate your contract, hopefully. Okay, for more information, I really took a look at the Title VI legal manual, which is put out by the Civil Rights Division of the United States Department of Justice. I put the link on there. And I'd encourage you to look at that. It has some really specific information in there, so it's obviously more detailed than what anyone will need. But it also has some very fact-specific information that might be helpful to people if they're wondering whether some of the practices that they've had in the past could possibly be discriminatory. That might give you some guidance. But if you have any questions, you can reach out to the coalition. We can try to help you. We're happy to do what we can to help you. And if you have any questions right now, I'm here. I'm ready to take them. So go ahead and send me your questions. And if you don't, I hope you have a wonderful day. And thank you so much for tuning in. I'm sorry I talked so quickly. But I enjoyed this webinar, and I hope everyone is just a little bit more excited about Title VI after this. All right, no questions? Then I am going to stop this webinar and have a great day, everybody. I speak very quickly. Hang up.